Yes, Your Lordship. Lordship, I beg to mention item number one and two, Your Lordship. My Senate in this court will be can come up on 7th of December.
MS
Wickets or no?
Learned Council for the petition has submitted that Green Council Mr. A. Jimom
Yes, Your Lordship.
for the petition in the petition number 1 in 2000 is in this post.
Yes, Your Lordship.
Is in this post and has paid for listing of the case on 12/2023. Mr. Tata Kishore and Council for the petitioner in the petition number 29 2020 and Mr. Imping from the petitioner advocate general for the state respondents are worrying the no objection to the state fair. For the party, it's on.
Lordship, I have seen your prayer for item number 58. Yes, Lordship, on 7th of December, Lordship.
After 2 weeks then. On the prayer of going to line of the
Lordship, 7, 7, Lordship.
7. For one Mr. For the and Mr. Current edition activity. Later. 7.
Please, Lordship. My lord, I'd like to mention hearing item number 52, 53, and 54. Kindly allow me 1 week time to file additional evidence.
Mess. You are a petitioner.
Yes, Lordship.
Okay. Or is present. Prayer of Mr. and Tivapon. Please. Learn from Mr. Tivapon. Learn has wait for a week's time, 1 week's time, to file additional evidence
Yes,
on
ma'am.
behalf of the state respondents. He has thus short listing of the cases after week 1 week. As the prayer is made with the consent of the transport of petitioners, this is the case after 1 week.
My lord, again, I'd like to mention item number 57. I have taken consent from the opposite party. Kindly list the matter after 1 week.
Okay, the prayer of Mr. Kiva from Rani State Council. Kumar, this is the case after 1 week. Post the week is taken that consent has been taken from the Rani Council for the petition to make the press.
Much obliged.
Yeah, please, your lordship. I beg to mention item 60. 60. On
Yes.
behalf of the council for the petitioner. Your lordship, if the matter may be listed after 2 weeks,
MS
accordingly.
only Rani Council paying for Mr. Sentianga,
Yes, your lordship.
Rani Council for the petition. It's paid for listing of the case after 2 weeks. It is submitted that consent has been taken from the Learned Council for the respondents to make up. This is the prayer is allowed, this is the case of 2 weeks.
Lordship.
Please, your Lordship, I'd like to mention item number 70, 71, and 73, Lordship, from the hearing list. Lordship, I have received instruction to appear on behalf of respondent number 4, Lordship. So I may be allowed 4 weeks time to file my reply, Lordship. So, to file my appeal.
Mr. Lima Wapang, Learned Council for the petitioners in all the petitions. All the 3. MS
Not simply language.
Learned Council has submitted that she has received instruction to appear on behalf of the respondent number 4 and to file counter affidavit. For filing counter affidavit on behalf of the respondent number 4, Ms. so has paid for 4 weeks time. The prayer is allowed. Is the case after 4 weeks. The office of the respondent number 4 shall ensure filing of counter affidavit on or before 4 weeks.
Lordship, I'd like to mention item number 69 to 61 to 69 of the hearing list, Your Lordship. This matter may kindly list objection, Your Lordship.
Who is for the petitioner? MS so and so, Learned Council for the petitions in this batch of petitions is present. MS
In the holy, Your
in
Lordship.
our holy Learned State Council. How much time?
So 3 weeks, Your Lordship.
Thus wait for listing of the cases after 3 weeks in order to complete our instructions. Prayer is allowed, list the cases after 3 weeks.
Much obliged, Your Lordship.
May I please, your lordship? Lordship, I beg to mention item number 73.
73.
Yes, my lord. Lordship, I pray that this matter may be listed after 2 weeks
You are for
for the private respondents.
your name, please.
Jiwalo
Mr. Ziwal. Who is for the petitioner?
For 3 for the petition.
Mr.
W. Mahul.
W. Marhu, Learned Counsel for a petition, and Mr. Thiba Hong, Learned State Council. For the state respondents are present, Mr. Surensu, Learned Counsel. For the private respondent, number, any number,
4 to 14.
4 to 14.
Yes, my lord.
Okay. As short listing of the case after
2 weeks.
3 weeks. As the prayer is not objected to by the learned counsel for other sides. Prayer is allowed, list the case after 3 weeks.
Lordship, I beg to mention item number 48. Instructions are yet to be received. Would grant us 3 weeks' time.
48.
I've informed the opposite party. Taken the past year.
Mr.
Mossam Longkono.
State,
Yes, your lordship.
State Council has submitted that the instructions, necessary instructions are awaited and has sought for how much time?
For 3 weeks. your lordship.
3 weeks' time to file counter affidavits to obtain necessary instructions to file counter affidavit on behalf of the state respondents. MS so and so,
Legal suit.
Learned Counsel for the petitioner is in attendance and has no objection to proceed.
Your lordship, a similar prayer for item 49.
Okay. Mr.
Lordship, in item number 48, the name of my senior counsel has not been reflected. Even in the last occasion, it has been instructed, but it's not reflected.
48,
Judge Jimoni,
Mr.
Abel Ayami,
Will Amy, Learned Counsel appearing for the private respondent has submitted that the name of MS J. Jimomi is not reflected in the call list. The office to ascertain the same and reflect the name of MS J. Jimomi in the respondent side of the call list. 49, what is the name?
Similar prayer.
Petitioner, Mr.
Similar.
Supong Wati Wali. Right, also for the petition. Mr. Surensu. State Council has submitted the necessary counter affidavit,
Yes, your lordship.
necessary instructions. Like 48. Yes,
Lordship, I beg to mention item number 51. Lordship, kindly fix the matter on 5th of this month.
5th of December. Mr.
Manekula.
Learned Counsel for the petitioner, come on, with the consent of the Learned Counsel for the respondents. Has made a prayer for listing of the case on 5th of December 2023. Where is the case recording? On 5th.
Maybe
MS, and it also
For respondent 1, 2, and 6.
for the respond number 1, 2, and 6.
Lordship, item number 55. Lordship, kindly list the matter after 3 weeks.
Mr. Surensu. If it's filed,
Yes.
hearing,
Yes,
Learned Counsel for the petition has prayed for listing of the case after 2 weeks. MS Inaholi, Learned State Council is in attendance and there's no objection. We would say, if this the case according to the treats.
Lordship, similar prayer for item number 59.
Same State Council. $59, you are.
Yes.
That's right. State Council. For the response. No action.
Lordship, item number 75. Lordship, I'm appearing for respondent number 5.
Respondent number 5.
Yes. Lordship, kindly fix the matter on 28th of this month. Okay,
Mr. Who is for the petitioner? Kohima, MS, learned counsel for the petitioner, and then Ms. Mary, you are there.
For the state, yes, Your Lordship.
It's 75. Yes, Mary. Learned state council are present. Mr. So learned counsel for the respondent of I.
Yes.
Have sought listing of the case after on 28/11/2023. Was the learned counsel for the other sides have also agreed to the same that Mr. Raise the case accordingly on 28/12/11.
And at number 77,
After which the prayer of Mr. Prince and counsel for the petition. The case stands adjourned for a week. Mr. Anybody? Praise made.
May I please the lawsuit? Lawsuit are the petition item number 76, lawsuit. On of the findings.
Sorry. Yes,
On behalf of my colleague, Superintendent Matcham. If this matter can come up on Friday,
Friday.
lawsuit.
okay. What's if I have an inspection letter on behalf of S.
In 76.
Yes.
Okay, Mr.
Please, Mon.
V.G. Momi. Learned State Council appearing on behalf of Mr.
MS, Superintendent Matcham.
As part for listing of the case on Friday.
Lawsuit.
Mr. So tonight after the petition. Being in attendance. Please like. Recording.
Lordship, I also like to mention item 78, Lordship,
Yes,
on behalf of my colleague, MS Livika, Lordship.
yes.
Lordship, I've been instructed that, the matter is under consideration, Lordship. So if this matter can come up after 2 weeks.
Petitioner side. Mass. We to see the council for the petitions present, Mr. E. Jimon. Lions State Council, appearing on behalf of MS Livika. And State Council, representing the state respondents. Has submitted that the matter. So the matter is under consideration. At the ends of the state respondents. He has asked paid for listing of the case after 2 weeks. 2 weeks. Master so my application will be put the same prayer. Will the case according after 2 weeks.
Sure. Lordships would like to mention hearing item number 79.
Yes,
I'm state here, lordship, let this matter come up next week.
okay. On the MS so and the application is present on the prayer of Mr. Moimship. Additional. Application. I can raise the case in the next week.
For motion, item number 81. May I please, your lordship. Your lordship, here the petitioner is approaching this honorable court for challenging the impugn noted dated 15 November 2023. And
Page.
also for non-consideration.
Page 1511.
Your lordship, may kindly see.
Page 20.
Yes, lordship. This is the appointment of the lordship.
Yes.
Yes, lordship, here the petitioner father, who is the landowner, had donated a plot of land for construction of the Rural Development Office at Kifiri. Now, your lordship, after the land was donated, the landowner in the department had entered into agreement. Your lordship mechanism annexure 3 at page 15. This is the agreement which was made between the parties, between the concerned department and the landowner. Your lordship may kindly see its second para, I may be allowed to read, lordship. And whereas the donor generously agreed to donate a plot of land of private land measuring area of so and so it is ward Kifri, which was roughly made and executed in the year 2010 on the pretext of extending service benefit to the donor. Herein referred to as Shiri is Leni Sangdam. And whereas the donate Department of Art Rural Development, if we plot in sound mind in without any has agreed to provide quid for opportunity as and when vacancy arise to the donor. Now, your lordship, this is the agreement which was executed between the landowner in the concerned department. Now, lordship, during the course of the time, a vacant post was arose in the department. So on learning about that, the petitioner, who is the landowner, had submitted a document by way of representation also. However, it was not considered. And without any following the process, they have appointed the respondent number 4, lordship. Private respondent.
Yes, State Council.
Lordship, I'll have to first see the instructions on.
But what about the appointment is very recent, 15/11,
Yes.
2023. He is making a claim that he is the landowner. So his case ought to have been considered. So what about this interim prayer?
Lordship, next day,
Interim, no,
first I'll
will stay this. Heard Mr. Tosi Kemjem Konjena, Learned Council for the petitioner, and Mr. Mohsin Law, Learned Permanent Advocate.
Yes.
For the respondent number 1 to 4. The case was elected in this writ petition. Is that. In the year 2010, the petitioner's father, Lenny S. Santang, within bracket, since deceased, donated his plot of land to the Department of Rural Development, Nagaland, for construction of office of the block development office, Kifire. It has been asserted that at the time of donating the land, free of cost, an agreement was executed. There was an agreement. There was an oral agreement between the petitioner's father and the state respondents for appointment to the landowner for uh, for giving appointment to the landowner in a grade 4 post. Subsequently, a written agreement was executed to that effect on 26/6/2023, wherein it was specifically agreed by the respondent number 4 that opportunity for appointment in grade 4 post would be extended to the donor landowner as and when vacancy arises in the office. When a vacancy arose, in a grade 4 post in the establishment of the respondent number 4, the petitioner being the landowner in respect of the plot of land donated for establishment of the block development office, KPD, submitted an application for appointment in the state vacancy. But according to the petitioner, state respondents, disregarding the better claim of the petitioner on landowner basis in the state grade 4 vacancy, have appointed the respondent number 4 by the impugn order,
5, Lordship. Respondent 5.
respondent number 5, by the impugn order dated 15/11/2023. The petitioner has asserted that whether he belongs to the landowner family,
No, Lordship.
the respondent number 4 does not belong to any landowner's family. Respondent number 4 neither belongs to any landowner family.
Respondent
5, or he has been appointed in the state post by pursuant to any valid selection process, any selection process. Issue is returnable in police as Mr. Swain has appeared and accepted notice on behalf of the respondent number 1 to 4, no formal notice to issue to the various comments. Mr. Swainson and counsel for the petitioner shall however furnish requisite number of extra copies of the petition and annexed to Mr. Swainson within 2 working days. Those for the petitioner shall take steps for service of notice upon the respondent number 5 by registered post with AD within 2 working days. Having regard to the projection made in the appropriate manner, considering the fact that more particularly the projections made that the respondent number 5 neither belongs to any landowner's family nor has been selected by pursuant to any selection process, the impugn order dated 15/11/2023 shall remain state till the return.
Much. Item numbers 3 to 43 and 84 to 90.
Make this motion. I have received an instruction for disposal of this item 3 and supplementary list item 84 to 90. I have received
Let us see.
as analogous.
Let us
I have received instruction on this manual. Your Lordship, if I am maybe allowed to read. Huge restraint zone, subject filing of affidavit for disposal of WPC number 82/2023 and 87 of 2023. In reference to the above cited subject and in continuation to this office letter dated 2/11/2023, we understand we'd like to request you to file an affidavit for disposal of the above mentioned cases which are fixed for hearing on 21/11/2023, along with WPC number 146 to 186 as per court order dated 14/11/2023, passing WPC number 146 to 186. As instructed, the department is also enclosing the breakup abstract of the damage compensation amount in PL number 9 of 2019, WPC number 82/2023 and 87/2023, and WPC number 146 to 186. The state respondent is praying for disposal in line with PIL 9 of 2019 for the remaining thinking with petition and PIL. The second page, running page 2 is
Yes.
PIL 9, for which sanction has already been accorded. Your Lordship.
Yes.
Running page number 2 is,
First table. First table.
yes, Your Lordship. First table is PIL 9 of 2019, filed by CPO, Chagasam Public Organization, and which was disposed of on 30th January 2022. For which the Ministry of Road Transport had already sanctioned 60 crore 94 lakhs 36,685.
WBC 81/2023 is not included.
Your Lordship. It is supplementary, it was list 84 to 90.
In the WPC number 81 of 2023, it's an item number 84, the supplementary.
No,
84 to
item number 84 to 90, right?
It's all analogous matter.
Right. Item number 84 is WBC number 81 of 2023. So it is not included,
It is already included here.
not included in your instruction.
Worship, in the instruction, in the second paragraph, it is typing your, it is from the WPC number 81 to 87.
But everywhere 82 to 87.
Yes, Worship. Yes, it's not included, 81 is not included.
It is in running page 3, Your Lordship. Abstract.
What about?
Each breakup is given, Your Lordship.
Yes, council.
He was hurt on last occasion.
Hmm?
By the friend, he was hurt on last occasion.
Yes, yes.
Your Lordship,
Mr. Seki, you have received the instruction raised by
Yes, Lord.
Additional Advocate General.
Yes, Lordship. But if my lord may kindly appreciate, the breakup is more accurate in the petition of my learned brother, Mr. Limawabang. Because earlier there was a direction from the Ministry of Road Transport and Highways to send a breakup. And that breakup, I did not include annex in my petition because I wasn't aware. But the same is available in the petition of my learned brother.
Oh, good. There are 3 abstracts.
yes, Lordship.
Right.
Yes.
I have checked up these 3 abstract. First table.
Yes.
See, if there is dispute, then that is a different matter. Otherwise, this sanction order, you are having a copy of this sanction order. So this sanction order is based on this abstract, first table,
Yes, Lordship.
60 crore 94 lakh 36,685.
685. Yes.
That is one part of the project. Then second abstract is regarding the 2 roads. Long Lang Sang Tongya Road and Mon Tamlu Merangkong Road and Kohima.
Lordship,
Total.
again, it's the report to Chakabama. Lordship, if
Wait a
you-
minute. Why you are impatient? Second table, see column number 2. Column number 2, second table. This table pertains to WPC number 82 to 87, right? And there are 2 district or 3 district, maybe. Name of the road, Longlang Santonia Road. So these petitions pertain to which road?
the first week petition, Lordship.
No, I cannot take care of 50, 60 petitions at a time. You have to say,
Motion by big petitions comes under column number 2, Surrender 1, 2, and 3. Longling to Chanduya Road.
Longlang Chang Tongya Road and Mon Tamlu.
Mon Tamlu Merangkong and Kohima.
So this is the assessment made by the deputy commission. That is 51 crore 24 lakhs 11,857. Right. Next, third table is that Juneboto Sakabama pertains to petition 146 to 186. Compensation amount assessed by the deputy commissioner is 8 crore 81 lakh 32,212. Any dispute? If you dispute, then civil suit. Right? If you dispute it, then civil suit.
Yes, sir.
Whoever beneficiaries are as per the district administration assessment, they will be extended the amount, and somebody is left out. He has no option but to lay his claim individually. If somebody out of this petitioner is not under the purview of assessment by the deputy commissioner, he has to institute a separate litigation. Because I wanted to know, because the state respondent has made a claim of about 120 crore as a cross obligation in the arbitral proceeding, right? Meaning thereby, they have impliedly admitted about this amount. Whether they would be successful from recovering the amount from the contractor or not, that is a different aspect. But liability lies ultimately on the state or union. So that is why I wanted the breakup. We respond number two.
Publication number one for the C. And I wrote the responding meeting, the Union of India, the Mobile Extension, Ministry of Work.
I'll go on dictating paragraph wise. Later on, we'll rearrange the paragraphs. But check the facts. Go on checking the facts as I am dictating the order. Take your seats. If something wrong is dictated, just stand up. So that it does not break my line of thinking. Heard Mr. Joshua Seki, learned counsel for the petitioners in the batch of writ petitions. Item number 32. 43. Within bracket. Hearing after. Referred to as the first batch of writ petitions. Bracket. And Mr. Lima Wapang, learned counsel for the petitioners in the other batch of writ petitions. That is WBC number, item number 84 to 90. Within bracket hereafter referred to as the second batch of writ. Also heard Mr. Zaid and Anguli, learned Central Government Council, representing the Union of India respondents. Hold on, Mr. L.T. Santam, learned Additional Advocate General from Nagaland for the state respondents. And
Assisted, Your Lord, assisted by VC.
assisted by Mr. V. Jimomi, learned government advocate for the state respondents, and Mr. Moa Jamil, learned counsel for the respondent, National Highway Infrastructure Development Corporation Limited, within bracket NHIDCL. From the comprehensive epic filed on behalf of the respondent Union of India. In the first batch of read petitions, comma, it has emerged that the Ministry of Road Transport and Highways, within bracket, MORT, Roman and H, comma, Government of India, is entrusted with the task of formulating and administering in consultation with other central ministries, so departments, area of honor, comma, state governments, for weekly administrations, comma, organizations and individuals, comma, policies for road transport, comma, national highways and transport research, with a view to increasing the mobility and efficiency of the road transport system in the country. The MORTH, comma, GOI, the roads wing of the MORTH GOI deals with development and maintenance of national highways in the country. Full stop. The development and maintenance of national highways in the country is being implemented by the MORTH, GOI through its implementing agencies, namely NH wing of State PWD, National Highway Authority of India, National NHIDCL, National Highway Authority of India, NHDI, NHIDCL, and Border Roads Organization, BR. The MORTH, GOI has taken up development of national highways, state roads and other roads in the northeastern region under a special program, VID, Special Accelerated Development Program Northeast, within bracket, SARDP dash NE bracket close, for providing road connectivity to all the district headquarters in the northeastern region by minimum 2-lane highway standards, apart from providing road connectivity to backward and remote areas, areas of strategic importance, etc. One of such projects undertaken by the MORTH GOI is the project of 2-laning of 4 roads. One, Longlang Sangtongia Road, Roman 2, Mon Tamlu Merangkong Road. 3, Peg Potsero Road. And 4, Juneboto Chakabama Road, Kolong, in the state of Nagaland, under the SARDP-NE to provide inter-district road connectivity. The first batch of repetitions is relatable to the road, relatable to Juneboto Sakabama Road, right? Your road is Juneboto Sakabama.
Yes, Lordship.
And the second batch of repetitions is relatable to which?
Longling to Chongdongya Road,
Slowly. Longlang,
Longling to Chongdongya Road,
Sangtongia Road,
Mon Tamlu Barangkong Road,
Mon Kamlu Merangkong Road.
and Kohima.
Kohima is not there.
Palam Tree.
No, in the table, but in the original project.
Kohima district it touched between the
No,
Chakapama in
I know the project is 4. Kohima under which one?
it will touch between Chakapama.
That I know. Meaning thereby which one?
Which way?
Have you understood? Meaning thereby which road? Take Potsu road. No. District Kohima.
Kohima district will touch between the road Chakapama to Zimbabwe. In between. So Chakapama is a ship, this is Kohima district. Chakapama is under Kohima district. So in the within
And
the
areas falling within Kohima district. Correct. The project of cold draining in respect of the aforementioned 4 roads was sanctioned by the MORTH GUI by job number SARDP-NE. So state roads, so ND, so PWD, so 2010-2011. Stroke 173 on 9/2/2010. Based on the detailed project report submitted by the respondent number 5.
By the state respondents.
By the Nagaland Public Works Department.
Yes, ma'am.
Public Works Department, Nagaland.
National Highway, Chief Engineer.
By the Public Works Department, Nagaland
National Highway.
National Highway. So it comes under PWD.
Yes, ma'am.
Public Works Department, Nagaland. Full stop.
Well, what may kindly include national highways because they have different.
I have said state of Nagaland. Public Works Department, it has 2 wings, 3 wings, but it comes under Public Works. No. We'll come to National Highway later on. Para. After the sanction was recorded, tender processes for awarding the contract works in respect of the aforementioned 4 roads were undertaken and in the state tender processes, one Messrs. Maytas, Maytas, that's Gayatri, within brackets, a joint venture between Messrs. Maytas Infra Limited and Messrs. Gayatri Projects Limited. Bracket close. Hearing up referred to as the contractor. Emerged as the lowest quoted bidder. Messrs. Metas Res Gayatri, within bracket JV, entered into a contract agreement with the chief engineer. Chief engineer. Chief engineer, public works department, within bracket NH, Nagaland. Now this will do.
Yes.
For execution of the construction of the aforementioned pole road. In respect of the construction works of the aforementioned pole works, the NH National Highway Wing of the Public Works Department, Nagaland, is the implementing agency of the MORTH, GOI to supervise and monitor the project contracts for a fee which is paid, stroke is to be paid in the form of agency charge. This is a contract date on 3/2/2011. Thus, the chief engineer public works department within bracket NH Nagaland has the role of supervision of works of the MORTH GOI as per the MORTH specifications and other specific specifications and codes as mentioned in the code agreement. The scheduled date of commencement of the project was 19/2/2011 and the same ought to have been completed by 18/2/2014. due to escalation of prices, cost of construction, the chief engineer, PWD, NH Nagaland, using the Kohima referred to as the responsible side, prepared a revised estimate of rupees 2978.20 crores and forwarded the same to the MORPH, COI on 20/02/2000. The respondent number 5 by the later dated 20/02/2012 had also reported to the MORTH DOI that several buildings, plantations, terrace field, gardens, etc. were to be demolished, destroyed during the hill cutting. And submitted cost estimate amounting to rupees 2316.66 lakhs to the MORTH GUI for that purpose. The estimate for damage compensation was sanctioned by the MORTH GUI on 3/5/2013 was for rupees 2316.66 lakhs. Para. The petitioners in the first batch of writ petitions have claimed themselves to be landowners of plots of lands located by the side of the proposed by the side of the Juneboto des Chakabama Road, where the two laning under the SARDP dash NE within bracket phase A was to take place. Full stop. The petitioners in the second batch of writ petitions have claimed themselves to be owners of lots of lands located by the side of the Longlang Sangtongia Road, Mon des Tamlu des Merangtong Road, and the and in areas falling within Kohima, whereby the proposed two laning were to take place. Full stop. Yeah. It is pertinent to mention that On being awarded the contract for Kohima, Messrs. Mehta's Gauhati, within bracket JV, proceeded to execute the contract work. Close the parent. From the affidavit in opposition filed on behalf of the state respondents. It has emerged that during the course of work execution, several buildings, plantations, terrace fields, agricultural lands, etc. were damaged, for which the first phase of compensation to affected properties were assessed stroke measured as provided in the estimate, which came to rupees 2316.66 lakhs. And the same was submitted to the MORTH, GOY by the letter dated 20/02/2012 by the respondent number 5. Full stop. Thereafter, several representations were received by the respondent number 5 for inclusion of compensation to genuine properties damaged due to the then going construction works. The Commissioner and Secretary to the Government of Nagaland, Works and Housing Department, had written, wrote to one, two, three, four, five, six, Deputy Commissioner, Kohima. 2, Deputy Commissioner, Napoxa. 3, Deputy Commissioner, Longland. 4, Deputy Commissioner, Mom. 5, Deputy Commissioner, Jonevoto. And 6, Deputy Commissioner, Pig. PHEK. On 22/8/2012, informing them that on conducting a survey for assessment of likely damages, likely to be caused due to the then ongoing construction works of the 4 roads covering 6 districts. A survey is conducted. First of by the state letter, he had asked for conducting a survey in each by the jurisdictional deputy commissioner in each of the 6 districts, so that all the damages caused due to the construction works could be assessed. Post of the jurisdictional deputy commissioner first were asked to make consultation with the officers of the PWD-NH from Nagaland. It was the jurisdictional deputy commissioners were requested to make necessary survey and assessment so as to enable the state government to take up the matter with the MORTH GOI. Right? He asked. So this is the result. The response number 5 had comma on 27/8/2012 comma directed the concerned executive engineers, PWD and PWD within bracket R and B to carry out the assessment of damages in coordination in their respective jurisdictional areas in coordination with the respective jurisdictional deputy commission. During the course of the as the construction, as the progression, as the progress of the construction works of the aforementioned four roads were tardy, comma, one public interest litigation, comma, PIL number 7/2013 was instituted by one Sri Ketobi Kaetobi Kapo before the principal fence of this court, seeking a direction to complete the project's construction works of the four roads under the SARDP-NE project at the earliest, and seeking other reliefs. Full stop. The division means the PIR was disposed of by an order dated 13/10/2015. With certain directions and also appointing a commission to supervise the execution of the contract works and also the payment of bids to the contractor. The judgment, the order passed in the in PIL number 7/2013 was challenged before the Honorable Supreme Court of India in civil appeal number 342/343/2017 within brackets Union of India versus Etopi HEPOPI, CAPO, CAPPO, and others by the Union of India. The civil appeal number so and so was allowed by an order dated allowed by the Honorable Supreme Court of India by an order dated 11/1/2017. The Honorable Supreme Court of India had observed that had expressed satisfaction that recorded satisfaction to the effect that the PIL initiated by the respondent number 1 therein, the PIL initiated by Toby Kapoor was with the sole object of having the road project completed at the earliest. Yes, Mr. Jamir, when the contract was terminated with Metas?
There is no report as the date of termination of India. Okay.
Before the Honorable Supreme Court of India, it was submitted on behalf of the Union of India that it had already foreclosed the contract with Messrs. Mehta's Gayatri JV. Pushpa. And to execute the construction works of the aforementioned routes by inviting press tenders. Pushpa. In the order dated 11/1/2017. Commandant, Supreme Court of India recorded satisfaction to allow the Union of India to re-tender the project, by initiating a press process, by following the contemplated procedure. Correct. Considering, taking note of the assurances given before the court on behalf of the Union of India, it was directed to the Union of India as well as the state of Nagaland, to ensure completion of the project, within a period of 3 years and 6 months therefrom. It was further observed that the consequences emanating out of the contract agreement dated 3/2/2011, executed between the state of Nagaland and Messrs. Mehta's Joyasrinigi Devi, Gayatri Devi, can only be settled in terms of the arbitration clause incorporated in the said agreement. Full stop. Taking note of the presence of the arbitration clause in the contract agreement, liberty was granted to Messrs. Mehta's Gayatri Devi to recover its dues from within bracket, if any, in the first instance from the state of Nagaland. And in case Messrs. Mehta's Gayatri Devi would be dissatisfied with the payment made to it, Messrs. Mehta's Gayatri would be at liberty to invoke the arbitration clause of the contract agreement dated 3/2/2011. Right? Correct? The order dated so passed in PIL number, order dated PIL number, order date 13/10/2015, passed in PIL number 7/2010, was set aside stop. By the order, set aside by the order dated by the Honorable Supreme Court of India by the order dated 11/1/2017. While allowing the same comma, it was further observed that in case the Union of India has any counter claim, comma, it will be open to them to seek the same, comma, in the same manner, comma, as has had been permitted to Messrs. Mehta's Gayatri in the arbitration proceedings, right? Before the arbitral tribunal. Yes, what happened thereafter?
By this, they filed the admission.
Where those details can be found? They had initiated arbitration, right? Yes, yes. Pursuant to the order of the Honorable Supreme Court of India, comma, a meeting was held under the chairmanship of Director General within bracket Road Development bracket close Roman N Special Secretary, comma, MORTH, comma, GOI. Between the with the officials of MORTH, GOI and the state of Nagaland. Officials from the PWD, NH, Nagaland, including the respondent number 5 on 11/1/2017. No, or not on 11. Full stop. Subsequent to the said meeting, the decisions taken therein was communicated to the Commissioner and Secretary, Works and Housing Department, Works Branch, Nagaland, and the respondent was right on 14/2/2017 in the following manner. There are nine. Of comprehensive ability of respondent number 2, A to A. Subsequent to the letter dated 14/2/2017 of the MORTH GOI, the respondent number 5 provide a letter dated 26/7/2017 submitted the details of assessment to the MORTH GOI. Full stop. In the said letter, the respondent number 5 had mentioned that the claim for compensation for damages caused during the execution of the project thereof amounted to rupees 120, 99, 81.755. Full stop. Apart from an abstract one page in your epidemic. In your
In the application number 126.
page 52 also of the respondent number 2 affidavit, same. And the following abstract of assessment of compensation was forwarded therewith. In view of liberty granted comma, no. In the meantime, the contractor, comma, Messrs. Metas dash Gayatri Devi submitted its final bill amounting to 1212.28 crores. To the respondent number 5. On 9/3/2017. On four nine 2017, comma, the respondent of 5 responded by its letter of event date, disputing and discarding the said claim of Metas Gayatri and had further informed that there would be counterclaim from the ends of the state of Nagaland. The same led to the initiation of arbitral proceeding with the invocation of the arbitration clause by the contractor, comma, Messrs. Metas Gayatri Devi. The arbitral tribunal announced its awards on 10/8/2019. Full stop. Before the arbitral tribunal, comma, a counterclaim for an amount of rupees 120 crores was raised as compensation was raised on behalf of the state of Nagaland by way of a counterclaim against Messrs. Metas Gayatri Devi on account of haphazard dumping of the excavated materials on the ground that the same was loss caused to the respondent number to the PWD NH Nagaland. Full stop. The counterclaim was, comma, counterclaim for an amount of rupees 121 crores was, however, rejected by the arbitral tribunal, observing that the documents relied by the counterclaimants were various abstracts of assessment of cost signed by the deputy commissioners. While rejecting the said claim on the by assigning regions, the arbitral tribunal acknowledged that the Union of India in its comprehensive affidavit has mentioned that the arbitral tribunal had, while rejecting the counterclaim by assigning region, had acknowledged that the contractor Messrs. Gayatri's act of dumping on the roadside might have caused great hardship to the local public. Para. After the arbitral award dated 10/8/2019, the respondent of 5 preferred an application before the arbitral tribunal requesting it to pass an additional amount vis-a-vis the counter claim, since the landowners of the affected areas are aggrieved parties from the illegal dumping that took place during the time of excavation for construction of the highways, which, in turn, had badly damaged the poor farmers' terrace fields, irrigation canals, crops, orchards, vegetation, fruit plantation, etc. The arbitral tribunal, by an order dated 16/10/2019, had dismissed the application, observing that it had no jurisdiction to pass any additional award. At the subsequent to approval accorded by the MORTH, GOI, by letter dated 27/9/2019, the respondent number 5 has challenged the award of the arbitral tribunal under section 34 of the Arbitration and Conciliation Act 1996, as amended, before the Honorable Delhi High Court, right? Full stop. The MORTH, GOI has also filed a separate petition before the Honorable Delhi High Court by means of petition by Honorable Delhi High Court, and the petitions, OMP within bracket COMM 25/2020 and IS stroke IS 677 678 stroke 2020. And those matters are pending as on date. As on date. Delhi High Court, which pending. In the meantime, come on. In the interregnum, comma. The MORTH, comma, GOI. Had, comma, on 14/2/2017. Comma. Had entrusted the work of supervision of the construction works of the aforementioned four roads to the NHIDCL in respect of which the right of way had already been acquired by making payment for the properties which were located within the ROW and are likely to be affected due to construction of two laning of the road works under the SARDP-NE project. At this stage, comma, it appears that it is necessary to refer to another proceedings in the form of a public interest litigation, comma, PIL number. Sequence is okay? Huh? Comma, PIL number 9/2019, within bracket, Second Public Organization and three others versus Union of India and seven others. The said PIL was filed by Second Public Organization through its functionaries on behalf of persons whose lands, properties, including crops, comma, irrigation and fields, comma, drainage, comma, etc., were damaged due to construction of two-lane roads within fake district under the two-lane project. It's Haida Road. It's Haida Road. 1, 2, 3, 4. 1, 2, 3 goes Haida Road under SARDP. There's any project. Praying for issuance of praying inter alia with direction to the respondents to pay compensation for the damages caused. The division bench in PIL number 2009 took notice of the fact that had recorded had took notice of the fact as to how the damages were caused to the nearby landowners due to construction works carried out by the then contractor, Messrs. Gayatri, Metas Gayatri, within bracket JV. The division bench had also taken note of the fact that the jurisdictional deputy commissioners had assessed it took notice was taken of the fact of the situation that during the process of the execution of the construction works, a lot of art cut works. Cut works, stones, trees, etc. were piled up along the roads under construction instead of dumping the same at the identified dumping sites, right? This is the cause. When the rainy season came, the materials were dumped. Along the roads, street down on the lands and properties of the villagers who are settled along the road, causing severe damage to their lands and properties. The division bench had also taken notice of the fact that on representations being made by these affected landowners, the commissioner and secretary to the so and so works, right? Commissioner and secretary to the what? Commissioner and secretary. Works and housing, Nagaland. on the instruction, on the direction. The jurisdictional deputy commissioner in consultation with the officials of the PWDNH Nagaland made assessment of the damages caused to these landowners and submitted the statement of calculation of damages before the respondent number 5. Comma, as already expected, carried. Yep, we have it. The PL number so and so. In the PIL, comma, the plea taken up by the state respondent was to the effect that the construction of the said four roads under the SARDP NE project was a project funded by the MORTH GOI, and the state of Nagaland was only an implementing agency. And thus, comma, the compensation ought to be paid by the MORTH GOI. Full stop. On the other hand, comma, the plea raised on behalf of the Respondent Union of India was to the effect that the compensation should be either paid first by the state and make their claims from the ministry, or claim the same in the arbitral proceedings, which was then pending. Full stop. Taking note of the respective projections of the parties, commander PIL number so and so was disposed of, and the relevant parts was disposed of by the order dated so. The relevant excerpts of the order dated 30/2023 are extracted herein below for ready reference. Paragraph 5 of the endowment. Paragraph 5. Subsequent to the disposal of the DL number so and so on 31/2023, comma, one paragraph. This court on 14/11/2023 had asked the learned additional learned Central Government Council and the learned additional Advocate General Nagaland to provide the breakup of or stroke service under which the Union of India and the respondent state of Nagaland authorities have made a claim for made a counter claim in before the arbitral tribunal and have made a claim for an amount before in the proceedings presently pending before the Honorable Delhi High Court. Yes. Mr. Sankam, an additional Advocate General Nagaland, has placed a copy of a communication bearing number so and so dated 16/11/2023 of the respondent number 3. Full stop. As per the as per the abstracts enclosed, the abstracts enclosed with the said communication, comma, rather than the internet. And it is all, it is apposite to mention that pursuant to the order dated 30/1/2023, passed in PIL number 9/2009, comma 2019, comma the MORTH, comma GOI White, its order number dated 27/10/2023 had conveyed its administrative approval, comma technical approval and financial sanction of the President of India, financial sanction for the payment of award based on the order of this court in PIL number 9/2019. Full stop. The damage compensation amount so sanctioned amounts to rupees 60 crore 94 lakh 36,685, which based on the calculation made, assessment of calculation made by the Deputy Commissioner of FIC for that part, for the areas, areas of land affected during the construction work of which part? Construction work of two laning of of Patsero Fake Road and Sakamama Junebot Road.
Puturo Road. Hey, Puturo Road.
No, that is the table. See the table you have submitted today. Both.
Yes.
Both. So. Puturo. The amount sanctioned by order dated 27/10/2023. Released with the abstract. For Petsero Fake Road and Sakamama Juneboto Road.
My lord, may kindly quote mention the volume, because the stretch of the.
No,
road is
I have,
pretty
I have typed, I am reproducing entirely, so I am not
Right.
going to
Right.
indicate. It will be typed and put there in the order,
long.
so that to diffuse confusion, right? So. From the above, from the fact situation, obtaining in the cases in hand, as discussed above, and from the stance of the respondent Union of India and respondent authorities in the Union of India and the state of Nagaland, it is evident that the and in their in various in the previous proceedings, as well as in the counter which filed in these proceedings, in these proceedings, in this batch of read petitions, it is not in doubt that there is the adjoining lands of the landowners, which were not acquired, were damaged due to irresponsible and haphazard dumping of the materials by the earlier contractor, Metas Gayatri Devi, whose contract had already been terminated. Full stop. As the claim for an amount of rupees, how much?
121 crore.
121 crore before the arbitral tribunal
Yes.
and before the Honorable Delhi High Court have been made by the state of Nagaland with the approval of the Union of India, and such counterclaim claim is made, has been made, which admitting that the damages to that extent has been caused to the landowners of the adjoining landowners. So whose lands are adjoining to the uh, uh, two lane adjoining to the constructions works of the aforementioned four roads where two laning works completed or not? Not completed till now. Two laning works, Mr. Jamir, completed or not completed? Were undertaken and still going on. Full stop. Does, comma, it is full stop. In such conspectus of facts, comma, this could it emerges that the responding authorities in the Union of India and the state of Nagaland have granted the prayer for granted the have admitted the claims in respect of areas of land damaged due to construction of due to execution of two laning construction works of Fetsero Fake Road and Sakabama Junebuto Road. Full stop. The respondent authorities in the Union of India and the state of Nagaland have not brought on record have not brought anything to rebut the claims made by the petitioners in these two batches of petitions, comma, as to why they are, as to why the landowners of lands adjoining to the Longlang, San Tomia Road, Monlu, Tamlu, Merantong Road, areas within Kohima district and Junebo to Sakabama Road. If the jurisdictional deputy commissioners have already assessed the compensation amount, they should not be paid. I'll correct it later on. There is no material has been brought on record by the respondent authorities in the Union of India and the state of Nagaland as to why the petitioners, the landowners landowners of areas adjoining to these the long rank Sangatama so and so are different to the landowners of areas adjoining to Kutsero Pek Road and Sakabama Juneboto Road in whose favor an amount of rupees 60,94,36,685 has already been sanctioned. Having in view of such obtaining situation.
Your Lordship, small submission. State respondent is only a supervisory agent. We are not likely to take any compensation.
In the same manner, in the PL. I'll dispose of in the same manner as directed in the PL. Why not? You decide among yourself. Because, see, union taken the stand that I have already recorded, right? I have recorded just now. I have forgotten. I have that. No. That they have taken the stand 1 minute. 1 minute. In your affidavit, Mr. Additional Advocate General, in your affidavit, I have quoted from your affidavit or Union of India affidavit, right?
In my affidavit,
No.
one page 11.
1 minute, 1 minute.
If I may be allowed to read.
11.
Yes, Your Lordship. Running page 11, Roman 18, Your Lordship. If I may be allowed. That the MRTH, White, its later dated 27/9/2019, had directed the Chief Engineer PWD National Highway, Nagaland, to challenge the award of arbitration tribunal in an appropriate court of law, as per section 34 of the Arbitration and Conciliation Act 1996, within 3 months of the date of.
That I have recorded already. Now come to the PIL. I have always, because you have taken the stand. You have taken the stand in the PIL that state government is only an implementing agency.
Yes, sir.
And compensation is to be paid by the Ministry of Road Transport and Highways.
Yes, sir.
And the ministry has taken the stand
Yes, sir.
that compensation should either be paid first by the state and make their claim from the ministry,
My lord, in the earlier.
or claim the same in the arbitration proceeding which is pending. So ultimately, you may have to pay, right? You may have to pay to the landowners, but you have to claim it from the ministry. That is what.
In earlier judgment and order 30th January.
No, that is a stand taken.
Nothing was mentioned in the judgment about the payment of such compensation from the state government. That was done.
In the cases in the cases in hand, that is, in these two batches of petitions, the damages caused to the lands and properties of the landowners having lands adjoining to have already been assessed by the respective jurisdictional deputy commissioners, and after conducting a joint survey and have submitted their statement of calculation of assessment before their higher authorities. It was on that basis, on the basis of such statement of calculation of assessment by the jurisdictional deputy commissioners, comma, the respondent Union of India and the respondent state of Nagaland have staked their claim before the arbitral tribunal as well as before the Honorable Delhi High Court in the proceedings, comma, pending as on date, which clearly goes to establish that there is admission of claim on behalf of the respondent Union of India and the respondent state of Nagaland authorities to the extent of amount incorporated in such statement of calculation of assessment made by the best jurisdictional deputy commissioners. Full stop. In such view of the matter, this court finds that these two batch of petitions, the reliefs sought in these two batches of petition is no different than the relief sought in the PIL number 9 of 2009. Full stop. In view of the same, comma, these two batches, the first batch of petition as well as the second batch of petitions are disposed of with a direction to both the respondent authorities in both the MORTH, GOI and the state of Nagaland to initiate the process for allocation of fund in consultation with each other, to initiate the process of allocation of fund and in terms of the abstracts, provide the communication dated 16/11/2020. This table. Yes, this table, Mr. Sekhi. Comma, extracted above. And thereafter, comma, allocate the fund to the jurisdictional deputy commissioners who shall, comma, in turn, comma, disburse the same to the genuine landowners whose lands, comma, properties, comma, standing crops and trees, etc., have been found damaged or destroyed during the construction of the aforementioned high roads. Full stop. If the petitioners in these two batches of petitions, if the names of the petitioners in these two batches of petitions are have figured in the amongst the such landowners, they should be disbursed the respective compensation amounts to assessed by the jurisdictional deputy commissioners. If any of them, because I do not go on finding, if any of these petitioners in these two batches of petitions are the entire process exercise should be completed within a reasonable time period, but not beyond 6 months from the date of this order. If any of the petitioners in these two batches of petitions is aggrieved by the process of such disbursement of compensation amounts, such petitioner will be at liberty to take recourse to appropriate remedy as permissible under the law. Anything? These tables are extracted. These table will be extracted so that no doubt remains. And whatever this area amount is there, that will be dispersed. I have to make corrections.
Yes, sir.
But sequence of events is okay?
Much.
Facts are okay?
Yes.
How many is voting?
Huh?
How many is voting? It's in a perfect harmonious voting.
The sequence of events, so many proceedings were there, right? You cannot visualize everything in a. Okay. Eighty by two. ইয়াতে আছে, খুলি ললে হ'ল।
Item number 44. May I please, Lordship, sorry for interruption, my lord. I beg to mention item number 80. I think today it wouldn't reach it, my lord. So let the matter come up on Friday.
Friday will be difficult. I have some, I have to
In
leave
fact,
early.
Lordship, the
I have to
argument
leave
is
early.
all the more completed, only one clarification about the. I was of the.
We can try on
Yes.
Thursday if
Okay.
cases are listed.
Lordship.
If you have got the instruction, you take the instruction.
Lordship, on Thursday, I will not be there, but my juniors are there and it's only for clarification.
Okay, if the
Then it-
clarification is received, we'll try, if we find it difficult, we'll
My lord.
refer.
Okay.
Right?
Lordship.
As sought for by Mr. Joshua Seki, learned counsel for the petitioners, and Mr. Chiba from learned state counsel is the case on Thursday.
My lord. Much obliged.
Yes,
This matter has been fixed for the mission hearing. The subject matter involved in this petition pertains to promotion from the
Huh?
post of promotion.
44, promotion.
It
Santa,
is short matter, Lordship.
short matter.
Yes.
I've been exhausted by
No,
the
The
previous batches. Anyway,
the sole issue is, Lordship, whether the petitioner is entitled for promotion during the tendency of the criminal. That is the simple issue. Lordship, what happened? In the year 2012, a criminal case was
it
registered.
can, now, if everything is prolonged, if everything is prolonged, and it is, say, runs into 10 years, maybe, then there is a, I don't know whether it is correct or not, ad hoc promotion kind of thing.
Yes, sir.
What is the law laid down by the Supreme Court? I am not,
Lordship.
no, it has to be some
Adult
authority.
promotion is permissible under the law.
Now, what authority? Any authority?
Lordship, there is a memorandum issued by the government of India. That during the. tendency-
Any authority also?
Lordship, yes.
Any Supreme
Only
Court
one.
authority?
One authority, the judgment passed by this honorable court. If there is delay in finalization of the criminal proceeding, the promotion can be possible.
Lordship, the case is that like we have undertaking a seal cover procedure, your Lordship. And my contention was that, your Lordship, if it is under a seal cover procedure, your Lordship, as and when the accused is discharged from the liability, your Lordship, he will get the benefit as he is supposed to get, your Lordship. Now, the petition is mentioning one memorandum, your Lordship. So in that memorandum, he's stating that permission should be done, your Lordship, but that will be subject to review, your Lordship. Because once it is a seal cover procedure is has taken, your Lordship, there should be a review, your Lordship. So subject to review, that is entirely within the jurisdiction of the TPC. They will look into this documents, and then only on consideration whether he will be fit for ad hoc or not, Your Lordship. This court actually, as per the memorandum, this court cannot give direction, at least to the extent that let the department have the committee, I mean, the review.
What about the
That is the
decision?
thing, Your
we
Lordship.
cited?
Lordship,
What about the decision, Ms. Devika?
Your Lordship, I have,
Just preliminary, because almost we are pushing one.
Your Lordship, I have, I have given a citation, Your Lordship, on a seal cover procedure. On the previous occasion, like on 2 occasions, we had an hearing, Your Lordship. And it was, it could not complete. Otherwise, I have already submitted my citation and even the petition. have
Okay,
been
there are
submitted.
so many notes.
Yes, Your
Somebody has heard it.
Lordship. Yes, Your Lordship.
Is he of my brother from this
Or
bench?
Justice Nelson also has documented that
And-
intensively, Your Lordship.
Oh,
Meantime, I was allowed to submit, like file an edition affidavit incorporating as to whether like inquiry report by the department has been done and whether it's in the seal cover procedure or not. So
what is the
accordingly,
stage of the
I filed.
criminal proceeding?
Your Lordship, still evidence because there are more than 100, Your Lordship. So during the pandemic, Your Lordship, there was little bit stagnation was there. But now it's like regularly going on. Previously, when we had the hearing, it was on 48 witnesses. So the charge sheet was filed in the year 2015, Your Lordship. And yes, and the case is taken up by NIA. They actually,
So it is 8 years.
yes, oh, yes, Your Lordship.
So your government of India motivation says what?
Lordship, the contention of the respondent authorities is that the case of the petitioner is kept under seal cover. But it's not only misconception, Lordship. Lordship, what happened?
No, what is,
It is not in seal cover, Lordship.
what does that government of India instruction say, circular?
That is with regard to seal cover.
Huh?
That is with regard to seal.
Where is the concept of ad hoc promotion?
Yes.
Where is the concept?
Lordship, before that,
No, I am just,
assuming that the petitioner case is kept under seal cover. The government of India memorandum says the seal cover procedure cannot be adopted for long. It should be renewed after every 6 months. Lordship, the petitioner,
and
Yes,
that, what, say, procedure is followed in the state of Nagaland? He is a state of Nagaland
Yes,
employee, Nagaland government employee.
police.
What procedure is followed in the state of
Lordship,
Nagaland?
For promotion to the boards of non-gazetted officers in the police.
Oh,
department,
no, I am not gazetted or
Yes,
not
Lordship.
gazetted. What procedure is followed?
Promotion should be done through the.
Whether they follow government of India instructions?
Lordship. That instruction has been passed based on the judgment rendered by the Supreme
This
Court.
memorandum is passed on the judgment passed by the apex court. Actually. That memorandum passed by the Supreme
Which judgment then?
Court.
Jangiraman case.
Janagaman,
Yes.
it speaks about review.
Yes, Your Lordship, in one column, it says that
I've already placed the
review.
government
should-
of India memorandum.
If seal cover procedure is adopted, then review should be done, Your Lordship.
There is already a report. Lordship. What is memorandum, Lordship? 14th September 1993.
One minute. You have submitted any affidavit in reply?
No, Lordship. No copy, Lordship.
Huh?
No copy. No copy.
Yes. It is just submitted like.
No,
this.
no, In this petition, what is your name? Longlise Sankam. You have submitted any affidavit in reply?
No, Lordship. And the lost copy, Lordship.
No.
He has not submitted, your lordship, but it was in, during the proceeding, your lordship.
No, I am asking you. He has filed a writ petition,
Yes.
right?
Yes, your-
You have
Yes,
filed
yes.
an affidavit in
Yes,
opposition,
your
I
lordship.
filed
right?
reply.
Yes, your lordship.
Then you have filed an additional affidavit in
Yes,
opposition,
your
right?
lordship. Yes, your lordship.
Have you filed any affidavit in reply?
Lordship.
File.
Yes.
That is what I am asking. Something is wrong here. You are long listed sanctum.
Yes, sir.
One additional affidavit in reply is on record, which speaks about B.Ed qualification. Wrong.
Your-
This, your affidavit is not on record. Reply. When did you file?
Reply.
Right?
To the additional affidavit, Lordship, I have not filed reply. Lordship. That additional affidavit has been filed pursuant to the court's order.
No, I have asked you, have you filed any affidavit in reply? Have you filed? Because that is with trace, it is filed. That is with trace, it has to be tagged with that particular WBC. If you have not filed, okay. Transfer. Perhaps not filed. If it is not filed, okay. Right? Mrs. Amin, somebody else's affidavit in reply has
Yes,
been
but I have
tagged.
not filed affidavit reply, that necessity.
So if it is not filed, otherwise you have filed, we have to trace out that.
No, Lordship.
Huh? Otherwise, somebody else's has filed an affidavit in reply in another repetition, it is inside this brief. These are with some B.Ed qualification. Here we are speaking about assistant sub-inspector.
Yes, sir.
He has no relation with B.Ed. Which document you have said? Government of India.
September 1992.
Ah. Have you, is it your pleaded case here for ad hoc promotion? Huh? It is your pleaded case?
Before Lordship, by the Indian order.
Have you given any type copy? Very small letter. Given any type copy here? No. Okay, leave it time. We'll try and resume at 2 o'clock.
It's short number.
We'll try. If possible, we should definitely.
Lordship, I seek your lordship's indulgence, your lordship. I beg to mention item number 74, your lordship.
74.
Yes, your lordship. This may be listed after 2 weeks. Your lordship.
Yes, you got the petitioner.
Yes, Lordship, on 5th December of. It's a long delay, this one.
Long, hardly 1 year.
Like a British to the family pension.
Okay, Mr. Wati Jamil and Council Board of Petitions present on the prayer of MS now the United States Council. Yes, on 5/12/2022, as agreed to by Mr. Jamil. United Council for the petition.
Much obliged.
Yes, what is the story here?
Lordship.
Let us see the facts.
Lordship, sorry for the indulgence. In fact,
Ah.
below the make a mention of
Yes,
item number 82 and 83. Lordship.
yes.
And since it's prayer, Lordship, this matter may be taken up next week. 82 and 83. Lordship.
On the, who is the petitioner? Okay, the joint prayer then. On the joint prayer of Mr. Mohajami, United Council Board of Petition, MSS, United States Council. Release the case after a week, same 83.
Lordship, I have a similar prayer for item 56, your lordship. Consensus
56.
prayer. Yes, your lordship.
Yes.
After 2 weeks, your lordship.
On the container. United Council Board of Petition is released on the prayer of Ms. S. Mary.
Lordship, it's a joint prayer.
Joint prayer
Yes.
of Mr. Tonga Pondena, Council Board of Petition and Ms. S. Mary. United States Council. Release the case after 2 weeks. Yes, Mr. Jamir, what is the story here? Let us go to the read petition. Let us go to the read petition first and
My lord, sorry
Yes.
for the indulgence.
Lordship, I would like to mention item 46 and 47.
46 and 47.
I'll be filing my certificate in opposition tomorrow.
Okay.
This matter will come up on Tuesday.
Let them file the counter affidavit and then I have not received the counter affidavit, so. Let it be.
Okay, Mr. N. Ram Kumar,
Yes,
my counsel for the petitioners is present 46. Mr. Moha Inchen. Okay, additional AG.
No, my lord,
Senior
senior government,
government, okay, Nagaland.
you are always
As-
speaking me additional aid.
So it is likely that. Senior government to get Nagaland has submitted that counter affidavit on behalf of the state respondents will be filed during the course of the week. Correct. Good, sir. You want next week? Or,
yes, after,
or
Yes.
file affidavit reply?
yes, if need be. I have not yet received the copy.
Council Board of Parties have submitted that the case be listed after 3 weeks, because 2 weeks, because if the petitioner side, wants to file any affidavit in reply, come on the same, may be filed within 2 weeks. Close the- Raise the case after 2 weeks. Same in 47. Same in 47.
Yes, ma'am. Immediately.
Petition and your petition. Yes, what is the story? Let us go slowly.
Your lordship currently to the government, which 19.
19.
That would be it can be
You are what? You are,
suspended. Nation I was suspended.
huh?
You the suspension of-
Assistant Sub Inspector,
Which will be
2003. Okay. Still you are Sub Inspector, Assistant Sub Inspector.
assistant sub inspector.
Okay, next post is Sub Inspector.
Which will be Lordship. By this order, Lordship, the petitioner was less than the suspension.
Arm set. 3,700. Very small,
That is the-
3,700
that is
rounds.
That is the allegation, Lordship. If I observe God,
Exercise 1 minute. It's
if you want that to be speech, you will know.
page.
Page 22, the back page.
What is 21? 22. Type copy of 21.
Yes, statement order. This order dated 15 December 2014. The petitioner was listed in service.
So in 2012, you were suspended.
Yes, sir.
Then in 2014, you were reinstated. Finalized with the National Investigating Agency.
Next page, Lordship.
23.
As I have submitted, Lordship, for promotion to the boss of sub-inspector. One should pass the CBT, serial promotion test. So
Okay.
the petitioner was allowed to go for the CBT and he was declared
Your serial number 42.
serial number 50.
You are allowed to appear in the central promotion test.
Yes,
You appeared
yes,
and the board recommended your case as passed.
yes.
Okay.
But therefore, Lordship, this period risks. But particularly defined, Lordship, take it to define.
Origin now.
Yes. And my security decision is serial number 35.
35.
35.
Long term petition. Yes.
Therefore, Lordship, the petitioner
Hmm.
is in fifth list.
In the
In the fifth list for promotion to the.
zone of consideration.
Yes. Lordship, serial number 36 to 42.
Huh.
Yes,
36, who are 36,
42
37, 38 also?
Yes,
Huh?
38, 39, 40, and 42. You were promoted in terms of this.
We are respondents here.
No, Lordship. You are my junior.
Huh.
So without considering my case, Lordship, junior has.
Where is their promotion order?
Page 28.
Page
28.
28 on it.
Next page is.
1 minute.
29 is good type of the Lordship.
Hmm?
29 type of. Yes. Serial number 36. Serial number 1 is serial
Yeah.
number 36.
Out 37. Become assume
39.
39. And some longer out 40. And in 42. Yes,
After promotion of my junior Lordship, I submitted a
who is
resignation.
years. What about this other two? 38 and 41? They were not promoted.
No.
Huh? They were not promoted. Okay, then you submitted your representative.
Yes.
Then what happened? 33 is the original one. Series of one. Hmm? Which one? 33 with reference to your letter. Huh? Hmm.
With reference to your neighbor, you guys would not like this, but look at the way of the commercial, you're right, but we do this. Whereas if you know, if it's still going to take. And this is still going to have. Here's the middle of the commercial, we consider only. That is the ground of dental, my promotion. By filing a PDP negotiation by the respondent.
Let us see their
They have
affidavit.
taken a control risk.
Let us see their affidavit. Two affidavits, right? First, let us take up affidavit in opposition.
Yes. Which.
Para 5. That is the allegation in the criminal case. Para 5, that is the allegation or in the criminal proceeding.
Para 7, para 9, para 11. Is 10 of the.
Okay, and additional affidavit, what they have brought. Let us see.
That includes. The memorandum. Whereby the inquiry has been proposed. To help the case to be different.
So what happened to the departmental proceeding?
No penalty has been imposed till yet.
Your lordship, it's in a seal cover, your lordship.
Huh?
It's in a seal cover.
Why it is in seal cover?
Yes, your lordship.
Why it is in seal cover?
Your lordship, as far as the information furnished to be by the department is that your lordship, actually the seal cover procedure was adopted just to protect the interest of the petitioner. So your lordship, what happened is that department proceeding was conducted, your lordship. And conducted.
Law is that departmental proceeding and criminal proceeding can go parallel.
Yes, your lordship.
There is no bar.
Yes, your lordship.
But if in a particular fact situation, it appears that the criminal proceeding would be more elaborate and evidence are of say of complex nature.
Yes, your lordship.
In that case, departmental proceeding can be stayed, can be kept in abeyance
Yes,
till the outcome in the criminal proceeding.
yes, your
But
lordship.
there has to be a formal order,
Yes, your lordship.
otherwise there is no bar.
Your lordship, what happened is that your lordship, as per the affidavit that I have filed, your lordship. The department proceeding was conducted, your lordship. And since, as correctly pointed out by this honorable court, the nature and the offense
Where is
committed.
that statement? Because two proceedings have been drawn,
Yes, your lordship.
departmental proceeding as
Yes,
well as criminal proceeding,
Yes, your lordship.
right?
Yes, your lordship.
There is no bar in continuing with the departmental proceeding.
Your lordship.
But if you have to keep it in abeyance, there has to be a formal order.
Yes, your lordship.
Just because the MS Libica's statement will not do,
Yes, your-
because the disciplinary authority has to take the call. If they want to wait the outcome of the criminal proceeding, they have to pass a formal order. Considering that the allegations in the DP and the allegations in the criminal proceeding are one and the same, almost one and the same. And so let us wait, because that is an exhaustive proceeding than the departmental proceeding. Let us wait for the outcome of the departmental proceeding. Otherwise, he is, apart from facing a criminal proceeding,
yes, your-
which is by an external agency, that is NIA,
yes, your lordship.
right?
Yes, your lordship.
And departmental proceeding, which is by the internal
Yes, your-
agency,
yes, your lordship.
right?
Yes, your lordship.
So he is not in control of that criminal proceeding. Because NIA is the prosecutor, they are the investigator, they will do according to their,
Yes, your-
and the special code,
yes, your-
special code over the proceedings of special code. Disciplinary authority has no power. But so far as the DP is concerned, if you want to keep it remain in abeyance, then there has to be a formal order.
Your lordship, since the nature and the offense committed by the petitioner is grave in nature, and therefore your lordship, it was kept in a seal cover, and accordingly his suspension was revoked, stating that it will be subject to the
Let us see
outcome.
that
of-
order. Let's
Yes, your
see
lordship,
that
the revocation
revocation.
order.
Let us see that revocation order. First, let us understand the entire thing.
Which
20?
21. 22 is not there.
No, there is no whisper.
Your lordship, the period of suspension will be finalized after the outcome of the criminal proceeding. Yes, your lordship. So, your lordship, since the offense committed by the petitioner is grave in nature,
No,
and if
so-
we see the charge sheet, your lordship.
While revoking the suspension order,
Yes, your-
you have not made any whisper about the DP. We made any whisper? No, we have said about only the criminal proceeding.
Yes, your lordship, outcome of the criminal proceedings, your lordship, and that reason, for that reason only, like we kept the proceedings under a seal cover. and revoke this suspension order, Your Lordship, and accordingly, subsequently, he was allowed to go for physical test, that is a central function test, Your Lordship.
And what about his prayer about ad hoc promotion?
Your Lordship,
Anything?
yes, Your Lordship, in that regard, Your Lordship, I have already placed my citation on Janikaram, Your Lordship, and the OEM has also relied on that Janikaram, Your Lordship. So if now the petitioner is in dispute with the seal cover, but that is our position, Your Lordship. We have actually put his,
Principle laid down in the Chandraman case.
Your
We'll
Lordship.
go, I'm not that fast as you.
So, Your Lordship, we have adopted that one, and accordingly, Your Lordship, I have placed my citation on the Janikaram also, Your Lordship. However, Your Lordship, admittedly, yes, we have not done any review, Your Lordship. So, Your Lordship, if we go by way of memorandum has also relied on the Janikaram's case. So, Janikaram's case, I mean. So, Your Lordship,
And that
DPC can
memorandum
be
is-
held and then.
That memorandum is applicable to the state of Nagaland.
Yes, Your Lordship, because,
Okay.
yes, so like, the direction can be given to the department to review his application, and like, if ad hoc permission is to be given, then let the DPC be constituted and like review his petition, Your Lordship.
Which part of Janaki Raman?
So, Your Lordship, on the OEM, Your Lordship, or
No, which part of Janaki Raman speaks about ad hoc promotion?
no, Your Lordship, I have stated like, ad hoc promotion.
Principle is different, Lordship, in the Chandraman case.
The OEM has relied on Jankiram case. I have relied on Jankiram case stating that seal cover, if we can kindly come to, Your Lordship, paragraph 17, Your Lordship. Starting from paragraph 16. What should be the view of the court when
Yes,
seal
let
cover
us-
procedure is
let
adopted?
us- Janaki Raman, order, it speaks about ad hoc promotion. Yes. Council for the parties. It speaks about ad hoc promotion also. But if I remember correctly, somewhere it is mentioned. I'm trying to find out. Read para 11 also. Janaki Raman. Which clause Roman 4, read. Yes, sir.
Yes, Lordship, that's why your Lordship, in light of this, since we have not held any DPC review. So your Lordship, under this circumstance, the review direction will be given for constituting a DPC to review the case of the petition.
Now, what is the division bench? What I told them. Subsequently, Janaki Raman, there are clear judgments. Supreme Court regarding ad hoc promotion. Are you aware of it?
No. Otherwise, lordship might be covered by the online.
One has to be interpreted also. And Janaki Raman has, where is that OM? Date of the OM?
OM is 1992, 14 September 1992.
Then Janaki Raman cannot be on the basis of OM.
No, Your Lordship,
Yes, sir.
OM has relied on this.
Okay.
Jankiram case.
OM is subsequent to.
Subsequent to the Jankiram case, and they have relied on, they have reproduced that one on the first paragraph, Your Lordship.
On this basis,
Yes,
clause 4, there are two other judgments of the Supreme Court.
yes, Your Lordship.
This. Are you aware? Three years back. I tell you. Thursday will take up as a first item to dispose of, dictate the order. Thursday. Huh?
Your Lordship.
Dispose of. On the basis of this, then I'll find out the other two judgments.
Oh, Your Lordship. Your
Specific
Lordship,
to that.
if I'm not mistaken, I've also submitted amendment with the. Yes, Lisa.
That is Saman Goel.
That one is subsequent to Jankiram case.
That is, I think, Chaman Goel, Chaman Lal. Chaman Lal Goel. Right? Okay, petitioner has made out a case. Heard Mr. Wati Jamir and counsel for the petitioner and MS Devika and state council at length. I'll leave the case again on Thursday. India admission column. Oh. Nowadays, there are some computers, it takes dictation also. I heard Mr. Wati Jamir, Land Council for the petitioner, and Mr. MS Livika, Land State Council for all the response at length. Good stuff. Please the case again for further hearing on Thursday. For me, answer.
Much
Partner.
obliged. Much
Partner.
obliged.
Partner. Yes, what is the story here?
Yes, Your Lordship, the petitioner is a retired typist. In 2004, she was allotted a departmental building. Now in two,
Oh, that one. No.
yes, Your Lordship.
These are disputed things. How can we decide all this? What is the amount? What should be the amount?
No, Your Lordship, they have determined the
Retaining
amount, that
wall.
department has determined the amount.
They have subsequently, they have taken a U-turn.
No,
Are you claiming this 35 lakhs?
Yes. There was a meeting in which they said they would like to reduce it and send it to the government again, Your Lordship. The petitioner said, all right. But they sat over the matter. So now,
Better to settle this through mediation. That amount you are claiming, there is some dispute. And it should have been calculated on the basis of SOR 2003, when the wall was constructed, not on the basis of 2016.
Your Lordship,
These are all,
yes, it was the government, their own officers who came and did.
I know how they work. No comment on that.
Yes, Your Lordship.
Don't force this court to make any comment.
Yes, Your Lordship.
How this 35 lakh estimate has been prepared, I do not want to make any comment.
Yes, Your Lordship, I would like to take Your Lordship to annexure
Is
A.
there any mediation sale here? Better both the parties go to mediation. try to have.
Your lordship, that would be very.
I think-
We don't have any mediation. since-
Recently, there is a notification I have seen. Notification mediation. Now mediation, something, notification has come for Nagaland. Let us see.
Your lordship, if that can be.
I have seen across the table, you should discuss through the mediator.
Your lordship,
A mediator is a mediator, he is an advocate,
yes,
otherwise
I have no objection.
trained in mediation.
That would be best.
I think it is the best way to go.
Yes,
We have a fully functioning mediation cell in the principal seat. There are trained mediators. These kind of disputed things can be settled through mediation if the parties agree. Say, both should come down, give and take policy.
your lordship,
There should be give and take policy on the part of both the sides.
your lordship.
Huh?
Your lordship.
In this type of cases.
Yes,
I think that is the best way to resolve the dispute, not through, because there are disputed questions. Let us find out that mediation
your
notification.
lordship, if that is there, it would be the best solution. Your lordship. Even the petitioner averse to.
Is there any trained mediator amongst you? Mr. Inchan? Any trained mediator?
Your lordship. It is unimaginable that the petitioner is running for 35 lakhs. Which was start executed during 2004. 2004,
Leaving aside all these,
that is why I'm saying. Okay, mediation also we used to do. We have a mediation room and then, but then, there is a panel of,
mediators,
not mediators, panel of lawyers from the Nagaland Legal Services.
Yes.
Authority, High Court. The lordship me, direct.
I think that is
Your
the
lordship, that would be good.
best way out.
Yes, your lordship,
Something give and take.
yes.
Give and take should be there.
Yes, your lordship.
Both sides cannot be adamant on their respective stand. If they go on taking their respective stands, then it is the petition will be involving disputed questions. Better to have a mediation. Okay. Let it,
Your lordship.
he has asked for it. Recently, about 7 days back, I have seen one notification regarding mediation sale in the state of Nagaland. And list of mediators are also there. You have a mediation room here.
We have panel that, okay,
No, you have a mediation room here.
we have that, but then that can be done.
Ah.
Well, mediators can go see the spot, how much can be made.
A
out.
new mediation act has come also. Central Act has come, mediation. Mediation Act.
No, mediators, what we usually do is we used to go in spot, verify the spot also, bring out the,
No, that is different. Here, mediation is that she is claiming an amount of money for construction of a retaining wall. Rightly or wrongly, an estimate has been prepared. Some stand was also taken that this is exorbitant. Second stand is that no budget. All these stands are taken. But if a responsible official from the department comes and sits across the table, then petitioner may come down with her claim.
Yes,
The respondent side may up their claim and reach at a particular consensus figure. I think that can be possible.
yes. Yes,
And even if, say, petitioner says 15 lakh, department says 10 lakh, then thereafter court can finalize.
yes, your lordship, there is a notification that is 17/11/2023.
Let us see.
Yes, yes.
lordship, department has said, not back.
I am just hypothetical. I am not saying anything about this case. I am just saying that both sides may come at a reasonable figure in the course of discussion,
Yes.
in the presence of trained mediator. What does it say? Please read. Please read.
This is a notice, this is Gauhati High Court. General notice dated 17/11/2023.
Ah, it has come, sir. Continue. In terms of section 5(3) of the Mediation Act, 2023, the secretaries of the High Court Legal Services Committee, secretary. I think he is the registrar or. Secretary, High Court Legal Services Committee. Registrar. And the outlying benches are hereby nominated as nodal officers for the respective benches for the purposes of inter alia, enabling appointment of mediators for conducting, oh, this is pre-litigation. Pre-litigation. One minute. There are trained mediators, list of mediators are there. Say for Kohima. Mrs. Medo Honu Karocho, advocate. Johnny Rengma. Do you know them? Sanjeev Rana. Demsu Waling.
Yes.
Demsu Waling. Kedubi Jotso. Rasivit Tuo Pulnu. Akatuli Ektomi. There is a fees for mediation also, 5,000 if settled. If failed, 2,500. Let us try to have mediation.
But not if I have no objection. In fact, that the government has been calling me every time I went and said, all right, you can reassess the whole thing again.
No, come both sides.
Yes.
Both sides may
Yes,
come.
yes.
Okay. Heard Mr. Ponjena. Let us try it as an experiment.
Yes, Your Lordship. Yeah.
If fails, it will come back again
Yeah,
after
but-
1 month. But things may work out also.
Yeah.
Learned counsel for the petitioner and Mr. Moa Imchen, learned senior government advocate, Nagaland, for the respondent. In view of the nature of controversy involved in this writ petition from our court, the court is of the considered view that parties be referred to parties maybe can be referred to mediation for mediation in order to find out an amicable solution. Amicable. In order to find out an amicable settlement of the issues involved.
This in relates to the payment, your worship, payment to be made for the construction of the.
I have understood, Mr. Jain. I have said,
This must have to bring out how much the government has to pay. Or, for that reason.
No.
no,
both
that is not
sides-
mediation. Both
Yes,
sides will come.
Yeah,
Both sides will come.
yes.
They will tell their respective story before the mediator.
Correct.
Then he will again go back to the parties to make them understand that this is the version of the other side. You come down with your claim. They will tell the director or whatever, but you intrigue your them. Then he will try to mediate and settle the issue,
Yes.
right? Full stop. The uh, the secretary of the High Court Legal Service Committee, Kohima bench. It can be before the district judge also. He is also a trained mediator, Kohima. Right?
Yes, you're not.
People, uh, Secretary, High Court Legal Service Committee, comma, Kohima, shall appoint a mediator from the list of mediators and shall appoint a date for appearance before the or appearance of the parties before the mediator. Full stop. In order to proceed with the process of mediator, comma, learned counsel for the parties shall present before the present report before the secretary, High Court Legal Service Committee, Kohima bench on Monday, Tuesday. Tuesday is 28th or better Wednesday. 29, 11, 2023 at 11 a.m. Full stop. The mediator so appointed, comma, shall furnish a report about the outcome of the mediation process after 6 weeks, within a period of 6 weeks. Within a period of 6 weeks from 29, 29/11/2023. First one. It will be done after vacation, right? Say 25 January, right? 25 January is not. Put the mobile, find out Monday or it should not be Sunday or Saturday. It is expected that the respective parties shall would extend all the necessary assistance and cooperation in the process of mediation, right? To stop. Release the case on 25/1/2024. Again on 25/1/2024 for the report of the mediator. You know what is the outcome.
That is the best.
One
solution.
should be also reasonable
Yes.
for the petitioner, I am saying. I am saying for the petitioner.
I know. He has,
There was no record.
yes,
At least the state has come up with a proposal or say some amount. There was no record.
there was no result because we have been asking the department. to
So,
come update and
She should be also reasonable, right?
She has been, she has
And-
been reasonable so far.
And who will be in the best position to make her reasonable? Mr. Ponjana.
Your Lordship. Even before coming to me, she has been very reasonable.
Okay.
Much of.
Yes, madam.
Lordship here, basing on the last one that was passed.
Okay. Hard MS Asa Rucha,
Yes,
the counsel for the petition.
notice is completed, Lordship. And it's a short matter.
The petitioner. Well, today it has come for orders, madam.
Yes, but if the matter can be listed after 2 weeks time, if it can be fixed on the 5th of December. before
After
the
2 weeks,
5th.
we'll fix. I have been fixing many matters, right? This is very new. After, we can say after 1 week, we can try to get it listed,
Lordship,
right?
if it can be 2 weeks, because
Okay.
I'll be out of station.
The petitioner was by the previous order dated 21/9/2023. The petitioner was permitted to take steps for service of notice upon the respondent number 1 and
Okay.
the respondent number 2 by way of also by way of dusting. Full stop. The petitioner has filed an affidavit, a compliance affidavit, stating inter alia that the notices for service by the state, routed to the registry or the banks, have been duly served upon the respondent number 1 and the respondent number 2. From annex and the same, it is averred that the notices were duly received by the respondent number 1 and the respondent number 2 under their seal and signature. Full stop. From annexer 1 and annexer A and annexer B of the affidavit, said affidavit, it transfers that the notices to be served upon by way of the state, which were routed to the registry, receipt of the notices, huh? Were duly acknowledged by the respondent number one and the respondent number two under seal and signature on 26/9/2022. Having regard to the above. Having regard to the statements and environments made in the affidavit. And taking, considering that annexer notices were received by the respondent number. The notices upon the respondent number one and the respondent number two by but service of notice says upon the respondent number one and the respondent number two by web trustee is accepted. Full stop. As the respondent, as both the respondents have been duly served with the notices from our let the case be listed after 2 weeks in the admission.